Good afternoon. This is George Yates, and I'm here with Justice for All for the next couple of hours. And I'm kind of excited today because I've got a great guest, Cheney Mason. He's an experienced criminal defense attorney from Florida, Orlando, Florida, and he's just written a book, Justice in America, about the trial of the century, Casey Anthony's trial. And how you doing, Cheney?
Hello.
Are you there?
Yes, I'm here.
How you doing? Listen,
I'm okay. How are you?
I'm doing great. Listen, I'm real excited about this show today because I read this book. It's called Justice in America. Mr. Cheney has had over 43 years experience trying cases in Florida. He's probably one of the most experienced criminal defense attorneys in Florida. He's a former president of the Florida Criminal Defense Attorneys Association. He's also on the board of the National Association of Criminal Defense Lawyers, and he was brought into the Casey Anthony case. Many of you who watched the wall-to-wall coverage of the Casey Anthony trial several years back remember there was a fellow named Jose Baez who was lead counsel in the case, and who Mr. Cheney was brought in, I guess, sometime after the case was originally charged. I'd like to start there, Cheney. And I know you've tried over 300 jury trials and counting. You're still practicing law regularly in Florida. And so I know that you've tried many other very interesting criminal cases. We might get to some of them. But let's talk about Casey Anthony, since that's what Justice in America, your book, is about. How did you get involved in the Casey Anthony trial in the first place?
Well, it was an interesting story, actually. I pretty well pay attention to all the cases that are going on around me. It's just an old habit. And I started observing, what was going on that maybe shouldn't have been, and what things needed to be done or done wrong, or in my opinion, just seemed to be done right, not done right. And the news media was just crucifying the defendant and defense counsel. So on one particular weekend, the Orlando Sentinel had a big story, a two-page story, exposing all the dirty laundry of Mr. Baez. It had nothing to do with the case. They were talking about his prior divorce and financial problems and whatever. There's no need for it. There's no justice in doing that, but they just really destroyed him in the press. And I took offense at that. I didn't even know him at the time. I had never met him at all, but from my position of having been the chairman of the National Association of Criminal Defense Lawyers Membership Committee for over a decade and president of the Florida Association, I said, this is wrong. So I decided I'd do something about it, and I wrote a letter to the Orlando Sentinel and reporter and said, look, if you're going to go to the trouble to try to assassinate the character and reputation of this defense lawyer, why don't you take a look at the prosecutor, this Mr. Ashton, and sent them references to and copies of a half a dozen appellate court cases where the prosecutor had been personally lambasted by the appellate courts for errors and mistakes and causing reversals of cases. And, of course, they never printed a word about that. They wouldn't say anything about the prosecution. Well, sometime after that, or about that time, Mr. Baez started calling my office, asking questions in general. There's a voice on the phone. I still had not met him. And after a few phone conferences of him asking advice or one thing or another, he then started wanting to come by and talk to me. And so this carried on for several weeks. Finally, one afternoon, I said, look, Jose, what are you doing? Are you trying to get me to try this damn case with you? And he sheepishly smiled and said, yeah. And I said, well, how much am I going to get paid? And laughed because there was no money. And I told him I'd have to talk about it. And after talk to my boss, to whom I've been married for 41 years now, she would have a say about what I do or not do in that regard. And after a couple of weeks of thinking about it, reflecting, and then going out and actually meeting Casey for the first time, I said, okay, I cannot turn my back on this case. He obviously needs help, and every all the odds have been stacked up against the defense in this case, and cases being convicted in the news media every day, every channel, several times. It was just relentless stories every single day. It was a fixture of the news, and I thought, well, we're going to try to even this out just a wee bit, and so I did.
And this was how many months after she'd been charged and the media had taken control of the case?
I think the litigation had been going on, some parts of discovery and some investigation for close to a year and a half when I got into the case. And so we had about the same amount of time, almost another year and a half before we went to trial.
Now, the jury selection process then was not to take place for, about another year after you got involved in the case?
Yeah, well, a little bit longer than that. Not much. We started in May of 11, and over in Clearwater, and so yeah, I haven't looked on the calendar to see, but it was about a year, probably a little bit longer from the time I entered the case. We started picking the jury.
Well, you've just written this book this year, 2014, Justice in America, how prosecutors and the media conspire against the accused. And I got to tell you, I read the book, and as a career criminal defense lawyer myself, I'm impressed not only with your depth of knowledge of the system, but how you're not afraid to go after the people that were in this. You didn't pull any punches against the judges, the media. You've got so many people. I'm not sure where to start. Let's start with Nancy Grace. I think that she's probably the most famous talking head in this Casey Anthony case, right?
Well, I want to be kind to her as much as I can, because she is, after all, a human being, I believe. But I think you've got her name wrong. Her name should be Nancy Disgrace. And I find her method and manner of journalism to be reprehensible and an embarrassment to, actually embarrassment to the country. It just there's no excuse in the type of show that she has and others like her that feel that their purpose in life is to insult and attack and to scream and just be wrong. Besides, I just can't tell you how lowly I regard her, and every lawyer that I know feels the same way.
Tell me a little bit about yourself. What is it that makes a guy like you take on a case like this? I mean, the first question is, what is it that makes you take on a case, no money, the odds are stacked against you, tell me.
I'm not sure I know the answer to that. Probably some psychiatrist somewhere would have a good time playing with my mind. I guess best explained it just kind of the way I was raised, or not. Actually, I'm not embarrassed anymore. I used to have some pride in my privacy, but I was effectively homeless when I was 15 years old. And I went from friend to friend, places to stay for different times, and until finally I went in the military. I joined the Air Force. I enlisted the day before I turned 17. And I turned 17 in the air on the way to basic training boot camp, which made me lawful. And so, I kind of always had the idea of being able to accomplish things, or trying to do things and not just be written off. There were lots of my friends and their families. They thought that when I dropped out of high school and went off to the Far East, that either I'd be killed or just never be able to do anything or amount to anything because I had quit. Well, I wouldn't accept that. I got my GED diploma in the military in basic training and came back and worked my way through school. So I've always been kind of the underdog myself, having to prove myself and having to come from nowhere. And so I have sympathy for others. And it's just in nature for me. It's ingrained when I read stories and see things about people who are being inappropriately attacked by news media, or by other people. It doesn't have to be media, just people that don't get a fair shake of life. It's not the fault of their own. I'm kind of there, and now I have the luxury of, after all of these years of practice and being pretty lucky, and having survived to be over 70 years old, I can do pretty well what the hell I want to. And if it means I choose to help somebody in a case, whether it's popular or unpopular, and whether there's money or no money, I can do it.
Tell us about Jose Baez, your co-counsel in the Casey Anthony case. He did not have as much experience as you. And how did he get involved in the case of defending Casey Anthony in the first place?
How did he get involved?
Yes.
As I understand it, he was down in the Osceola County Jail to visit somebody on some very minor little misdemeanor case, or maybe it was felony, I don't know. And this Casey Anthony had been arrested and was in the pod, the big cell, with this young woman. And the other woman said, "Well, I have a lawyer. I like him, and I'll ask him to see you." And that's the story as it was told to me, that he did start talking to her and basically volunteered his services to her, at the jail, because she was not charged with a homicide at the time, but the child was missing, and all the stories were going around and around about probabilities of that, but she was only charged with some bad check minor cases. And so he undertook that with her then.
Mr. Baez had never tried a capital murder case. Had he tried any kind of homicide case?
No. He has only been, he was only a lawyer, member of the bar about 3 years at the time, and had worked as an assistant or an intern in the public defender's office in Miami, as he told me. He had not tried any major cases of any kind. The routine where you start off with kind of entry-level lawyering is what he had been doing.
The pressure, I suppose, on you to take over as lead counsel must have been immense.
Well, let me correct that. I didn't take over it technically or in quotations as lead counsel. In fact, I refused. I told Baez, if he wanted me to try this case, I would do it my way and how I wanted to. But as far as who was going to be the designated hitter as lead counsel, he had to remain, and that was going to be his job. And I believe there could only be one captain of the ship, and I told him I wasn't going to come into a case 18, 20 months after things had been done right, wrong, or indifferent, and take the responsibility and blame for it. I would do what I said I would do. I would set the strategies and help doing every aspect of it I could, and I would try the case to the jury. But so Jose maintained the label, if you will, of being lead counsel, no matter how it appeared.
You wrote some incredible motions, which are contained in the book, and anybody that's listening here today, and we're going to put this show on our YouTube channel. It will be on my website later, so if you can't listen to the entire show, you can go to www.ghylaw.com. That's ghylaw.com, and you can get the full interview here with Cheney Mason. We're on Justice for All here, 1650 AM. Cheney Mason is the author of Justice in America, and he was co-counsel to Jose Baez in the successful defense of Casey Anthony, the trial of the century. When you got involved in the case, well, first of all, I'm so impressed with some of the motions you filed, but now was Judge Strickland, you actually filed a motion early on in the case to have the judge that had been hearing it recused from the case. How did that happen?
Well, he had revealed himself, frankly, as having prejudged the case. Not characteristic of him or his reputation before, but he had in this case, and it was very clear to all observers that he had been. And so I started looking at it and wondering, and then I was told by, initially by one of the volunteer interns about this incident that the judge had just been talking about a blogger that he was watching it. I couldn't believe that. First of all, I have to confess, as you already know, I'm an old guy. At this point in time, I didn't know what the hell a blog was, and had certainly never done it, never have since. But I soon got educated by the young folks around me what it meant, and lo and behold, they were able to pull up on the computer the judge calling into the courtroom at the end of a session, telling the deputy in charge there, as a sergeant, to tell that fellow in the blue check shirt there to come back here. I want to talk to him. The camera was running. This is one of the things I say. I guess I have to be a little hypocritical about how damn happy the TV camera was there, because the camera was running and nobody was paying any attention to it. But lo and behold, it captured the judge asking this fellow to come up to the bench, and you hear his voice and you see the guy, and the judge's hand sticks out, and the judge says, "Are you?" And he tells the name of this blogger's name. And he said yes, and of course the guy that was the blogger, he didn't know what was going on. He had an obvious look of fear and trepidation on his face, being called back into the courtroom and across the bar and up to the bench. And the judge reaches down and says, "Well, I want to shake your hand." And so the guy looked at him quizzically, and he shakes the judge's hand, and the judge says to him, all recorded now, and the judge says, well, I've been reading your blogs and others, and I have to tell you, you're the best one. You seem to be really accurate and on the money, and I just want to shake hands with you. Well, then I look at the blogs that he was congratulating and approving this guy of, and they, believe it or not, were blogs that had big headlines: "Casey guilty as charged," "Casey must die." And I'm just absolutely in disbelief. I could not believe that anybody would be so low as to say that kind of stuff anyway. But of course, it happens every day. I just was unaware of it. But then to have a judge that is sitting on a case, any kind of case, and most particularly one that the death penalty is at stake in, and congratulating a social media guy who has already determined that she was guilty and calling support for her to die. I think that was the most reprehensible and offensive thing I had ever seen in all of my decades, not just as a lawyer, but as a human. And so I told the rest of the folks, I said, I'm not going to tolerate it. I had some debate. The rest of some of the other folks on the team, including Jose, were very reluctant to take on a judge. Well, you go back to where you started with me. I'm older and much more experienced, and I didn't care. My job was to save Casey Anthony's life, to represent her best I could, and I'd just be damned if I was going to let some judge sit around in such a biased and unbelievable situation that you think it was something that came out of the 30s or 40s, and it was a racial question or something. I don't know, but at any rate, so I took him on and filed the, as you say, very lengthy motion to disqualify him, and that was that. And then, of course, when I have to tell you, a fun part about that is being old and the experiences that I have had, I thought I would try to do it the professional and at least polite way first. So we had a hearing on some unrelated matter, and the conclusion of which I told the judge I needed to approach the bench. And nobody else knew why I was going to approach the bench at that point in time. He said, of course, okay, motion is forward, and so the prosecutors all go up, and we go up, and all of the news media has packed the courtroom there every day for whatever reasons. Nothing important really going on, but they were there. And I said, Judge, I'd really like for us to go into the back office back here, the back room here. I want to talk to you about something privately. And he looked at me like I had three heads, and he said, well, how can we do that with all the news media here? What are they going to think? We can't do that. No. He said, what do you need to talk about? And I said, well, Judge, I really mean this. This is something that should be done privately. Prosecutors have no idea where I'm going. And again, the judge said, no, we can't do that. And I said, what is it? And I said, well, Judge, I have to tell you, I'm filing a motion to disqualify you. You don't belong on this case. Well, you can imagine the looks of the lawyers standing up there with me, and of course the press cannot hear. And they're all looking to see what's going on, and the judge wouldn't do it. He just said no. I wanted to give him the professional opportunity to simply disqualify himself with a one-line order that did not require explanation or embarrassment or humility to him. He wouldn't do it, so he got what he wanted, and that's why I laid it out. There be no mistake about this. This fellow did not need to be a judge on this case, and with that type of attitude, in my opinion, on any case.
Had you
As a
ever...
result of that, and another later transgression on his part, he resigned and is no longer a judge.
And so Strickland, his name was Strickland, and he is no longer a judge in Florida. Was it because of that, this particular incident, or was it something else?
Well, I'm sorry, say that again. I couldn't hear you.
I say when he left the bench, was it because of this, or was it from something else?
Well, he resigned. There were some matters undergoing at the time. They're required to be confidential, but the bottom line is that he just decided rather than carry on and have any other investigations or problems all related to this case, he resigned, and that ended the process. And I don't know what he's doing these days. I mean, he's still a member of the bar, but he'll never be a judge again.
Yeah. Clearly, from what he had done in that case, he had no business being a judge. Had you ever done that before, asked a judge to leave a case?
I had twice before asked a judge to be disqualified. Once was a few years, about 3 or 4 years before that, and another a multi-count first-degree murder, capital murder case. The judge that was initially in the case when we were trying to pick a jury just did not have a comprehension about capital cases and qualifications for jurors, and kept making rulings that were so bizarre that, believe it or not, the prosecuting attorney and I joined together and filed a joint motion to disqualify that judge. It may very well be the only one that's ever been filed in this country. I've been asking colleagues from coast to coast, border to border, from time to time, over different cocktails and other meetings and conferences ever since that case, if anybody ever heard of it being done as a joint motion, and nobody has. So that was one disqualified that judge, and a new judge took over, and we went on. One time before, years before that, I disqualified a judge in a divorce case. And the irony is, this particular judge in high school had dated my sister. I had known him forever. But he interrupted a trial on a Friday afternoon without letting us finish it because he had to go to Gainesville to watch a damn basketball game. So I said, no, we can't have this. And, filed a motion to disqualify him, and it was done. And then we had to try the case all over again, rather than be able to finish it because he had to go to a basketball game. So stuff like that happens, and lawyers have to be vigilant about that. And it was what he did was wrong. It hurt my client. It hurt the opposing client. It cost everybody, both sides, money and time. And I just wouldn't tolerate it. You go to a basketball game? Are you kidding me? I don't care if it's the NCAA finals. If you're in court, you got a job to do. Yeah, that was my experience. I've only in now over 43 years of trying cases, I have only filed motions to disqualify those 3 times.
That's quite a rarity. We're here with Cheney Mason. We're on Justice for All with George Yates. It's K-Talk Radio, 1650 AM. We're going to take a short break here. We're going to come back, and we're going to talk about capital murder defendants, other cases that Cheney Mason has tried in Florida. And we'll be right back here with Justice for All after these messages.
Fink's Car Care, with locations in Chesapeake and Portsmouth, is your dedicated Tire Stars dealer. At Fink's, their experienced staff specializes in brakes, steering, suspension, tune-ups, oil changes, and much more. They also handle rebuilt engines and transmissions, and they're your destination for tires, rims, and towing as well. Fink's is located at 2236 South Military Highway at 2711 Victory Boulevard. For more information, log on to finkscarcare.com or call 545-3573.
WHKT is on Facebook and Twitter. Like us on Facebook, WHKT AM 1650. Follow us on Twitter at WHKT AM 1650 and stay in touch with K-Talk 1650.
For the very best in down-home music, join us on Saturdays, 11 a.m. for Ramblin' Ralph's Bluegrass Special with the authority on bluegrass music, Ralph Coleman. Saturdays at 11 a.m. on AM 1650 WHKT. Ramblin' Ralph's Bluegrass Special.
Okay, we're back with Cheney Mason. I'm George Yates. This is Justice for All, 1650 AM. But I know that we're talking about the Casey Anthony case, and I'd like to get back to that in a little bit, Cheney. But you've defended a lot of capital murder cases, and do you have any clients that have been convicted and gotten the death penalty?
I have one client that is currently on death row and is still involved in the appellate process that maybe we'll get relief, maybe not. I don't know. That's the only one.
Yeah, Florida is very well known for being one of the states that doesn't mess around and actually does execute people, and you're there doing that. And you've lost one at least. But have you ever had one executed? No. Okay, so I had a guest on my show last week or a couple of weeks back. His name is Nick Yaris, and he did 21 years up in Pennsylvania for on a murder that he didn't commit. He was ultimately exonerated. It was an Innocence Project sort of thing. He actually did some time there in Stark next to Ted Bundy because he'd actually escaped from Pennsylvania prison and got caught in Florida and did some time there. And anyway, that's another show for another day. But when you defend capital murder cases, briefly, when we go to that, you've had some that you've defended for the death penalty and then been, successful in getting them life?
Well, I've handled a number of first-degree murder cases. I'm really not even sure how many. I've won many. I say one. It's on the definition. Lesser charges, second degree or manslaughter, and of course several just not guilty. The truth is that more often than not, these types of cases ultimately get resolved by some kind of plea bargain, sometimes early and sometimes late. I have actually handled 3 homicide cases since the Casey Anthony case. One completely dismissed an acquittal. One verdict of manslaughter for 15 years. That was one that the state had assured the public was going to be a death penalty. And another one that was acquitted. And, you just never know where they're going to go. Sometimes people get, sometimes prosecutors overcharge cases. I'm sure you know that. And sometimes the evidence doesn't work out like they thought it would be. There's all kinds of things. There's so many variances that can happen between, just guilty and it goes to the death penalty or not. I think, thinking back, the first time I defended a first-degree murder case was a jury trial was in 1973, and that one, my very first run at the big league of that, the jury convicted my client of manslaughter, and that was considered substantial. as opposed to what could have happened.
What do you tell people when you're a criminal defense lawyer and you run into the typical person that says, how can you defend people that you know are guilty of a crime, or whatever the questions that come?
You know what, George, something faded out on the call. I didn't hear you.
I say, being a criminal defense lawyer for many years, so many people will, at the cocktail parties or whatever, and you tell them what you do and what you specialize in, and they say things to you like, how do you do that? How do you defend somebody that you know did it, or how do you defend somebody that committed such an offense? How do you? What is your general response to those kinds of questions?
Well, for decades I've wanted to have some really clever, patented response to that question that, as you know, we all get asked hundreds and hundreds of times. And kind of what I do is I just look at them and say, you know what, I would even represent you.
And when you took the Casey Anthony case on, did you encounter your book says that you received a lot of congratulations from your colleagues, and is that generally did that happen in this case when you took on the Casey Anthony case? How were you treated by your colleagues at the bar?
By the bar, very well. Lawyers understand. There are some that obviously. Lawyers don't all think alike. I mean, I don't want to cause trouble in your show there, but we have some lawyers that are actually even Republicans.
I did not watch the Casey Anthony trial coverage very much. I must confess, I was one day. I think I was meeting with a client, and I was in an area where there was a television. I think that the verdict was just being read, and everybody, of course, around me knew all about it, and I had not really paid much attention to it. I might have been one of the very few that didn't know much about it. So let's talk about the case. I'm sure there's some people listening to the show now that know all about it, and some who don't know any. What was Casey Anthony trial all about in the first place?
Well, I guess the underlying problem that we had to deal with was there was a death of a little angel, an absolute beautiful little girl, beyond words of how cute she was and how playful and nice and everything wonderful she was, and she was dead. And it caused a big stir about that, and I hate to invoke some racial stuff, but the truth of the matter is, we have had lots and lots and lots of young children, young cute little girls found dead that were minorities, and just don't seem to be of interest to the news media and the public in general, which is unexplainable. But this was a cute little white girl, and a very cute little white mother defendant, and I think that's where it got the attention most. And once it started, it just kind of kept rolling and building and building and building, until there was the group of haters and the people that wanted to label Casey as the most hated woman in the world. And in reality, the hard facts of the case were really not much different than hundreds, if not thousands, of others. But it was made into a major show. I mean, that's what it was. The local television stations continuously, every day, the news teasers would be, the case against Casey, new developments, case against Casey, news at 6, and that's what they did. It was a standard, just like watching in the old days Walter Cronkite and the 6 o'clock news on CBS, and now it became the story, the case against Casey. And so once it got started, it couldn't be stopped, and even after the jury verdict, it still didn't stop.
And this was her daughter, Kaylee was her name?
Yes. And
she was missing, though, for the longest time, right? They had not discovered the body, and so...
Well, she really wasn't missing to the world, to the public. She was missing. Yes, the remains were not found for several months. after she was disclosed as supposedly being missing. The child was the disclosure of the child being missing was in June, and remains were found in December. So, and so throughout that whole period of time, there was the question about what happened to her, where is she, and her mother must know, and her mother must have done this, that, and the other. And you know what? That's common sense. And I understand that. And I don't fault people for thinking that, but they didn't know what I knew, and they didn't know what had happened. Basically, as I believe, to Casey when she was actually made aware, confronted with the fact of the death of her child. Her mind snapped, and she was in the Casey world, and that's what we refer to the Casey world. She just was there. So, you know, the press made a big deal out of it. The public did, and it's understandable. A lot of people wanted to know, you know, what happened, and they would show pictures of this precious little girl. And interestingly enough, all the pictures were her with her mama, now the defendant, and how happy they were together, and how wonderful they played together, and the great bonding relationship that Casey and Kaylee had. But Kaylee was gone, so. Well, the mystery was there, the hyperactivity of the search for the child, and all of the things that were going on like that just made it a story every hour, on the hour.
What was it that made the overwhelming case against her in the media? There was everybody in the country, except for the jury, believed that she was guilty, apparently. What was the overwhelming evidence against her that ultimately the jury didn't accept?
Well, I have to tell you, there was no overwhelming evidence against her. There wasn't any evidence against her. The only issue there was one that nobody could get over, and still there'll be lots of people never will, was the fact that the child was missing for a period of time before it was ever discovered that she was so-called missing by the grandmother and grandfather. When they asserted that they just learned that their granddaughter had not been seen for 30 days. Going beyond that, there never was any evidence of any kind, and I went through that in pretty good detail in the book, because there were so many outrageous assertions. Trying to drive the square peg into the round hole is what the prosecution did their best to do. And they couldn't make up their mind what the theory was, and they had no meaningful theory of reliable science. They had junk science and remarkably incompetent things that were allowed into evidence by the judge, and all designed to inflame the passions of the jury. But we had a bright jury. And as you say, they were sequestered. They weren't confronted with the daily and nightly news and the prejudice that came out of the media and all the things that were being said by the talking heads of inexperienced lawyers posing as experts who themselves had neither credentials or experience. The jury didn't have that. They relied on what actually happened in the courtroom, not what some news reporter said happened in the courtroom. And that's why they, after a 6-week trial, had a verdict in less than 11 hours.
We're here on K-Talk 1650 AM. I'm George Yates. I'm your host for Justice for All. I'm here with Cheney Mason, co-counsel on the Casey Anthony trial, tried in Florida several years back. He's the author of a new book, Justice in America, How Prosecutors and the Media Conspire Against the Accused. If you were to, Cheney, if you were to put it down to one, let's say one smoking gun fact, I know you did a closing argument in this case. What was your closing argument for people out there that think that Casey's guilty? What's your what are your reasonable doubt points that you made in your closing argument in this case?
Well, I guess the best way to encapsulate that is saying I wanted to explain to the jury what is really truthfully and validly meant by the concept of reasonable doubt. And so I used a visual aid board that's kind of famous now, being copied around the country.
Can I have one?
Well,
can you send me one of those? I saw a picture of it in your book.
You can make one. I mean, actually, the visual aid company that made that for me some years ago, is out of business. I first used it. I guess another high-profile televised case I did was a racial profile case. I represented a Miami police officer, a Major Aaron Campbell, an African-American that had been profile stopped in Orange County and searched and abused and so forth. We had a long jury trial on that. That's the first time I used that board, and since then I've used it in numerous cases, homicides and others. And it really was just to try to point out to people, what is reasonable doubt. It's just not some kind of term that's there by itself. And you go through the list of things. Well, probably did it. That's all in the doubt area. Maybe she did it. That's in the doubt area. Could have done it. Likely. All those different adjectives that are used in common language, all are measures of reasonable doubt. And I enjoyed doing that because it really helps focus the jury on what that concept means, and the prosecutors hate it. But I've had some try to stop me from using it in the court, and I just say to the judge, well, what's the difference between me putting this up here where it's very legible, or me just getting an easel out here and writing it in my lousy penmanship in front of the jury? I'm going to say and do the same thing, and you can't stop me. So, it's used and copied. My colleagues at defending the Sanford case, Zimmerman, Trayvon Martin case, they used by board. They just turned it around and did it laterally and used the same thing. And, it's really important for juries to understand what is meant. You can't just say, well, perhaps she did, or more likely than not, or maybe, or could have, or whatever. Proof beyond a reasonable doubt is a pretty strong burden, and that's why we have it in our society and under our Constitution.
And so, what was the proof beyond a reasonable doubt in the Anthony case? What was the reasonable doubt?
Well, oh my God, there's a long list. Let's start with the things that I tried to enunciate most clearly. How did the child die? There's no answer to that. Where did she die? There's no answer to that. When did she die? There's no answer. Who, if anyone, was with her when she did die? There's no answers to any of these that could be presented by the prosecution then, now, or ever. And so, you certainly can't say, I'm going to, lawfully convict somebody of a crime and even send them to death when none of these fundamental questions can be answered. And that was the whole part that I went after. I knew from the forensic evidence and medical evidence that there was no ability to answer any of those questions.
Wasn't there some question as to whether the body had been moved? As I read through your book, and once again, I'm somebody that didn't follow the trial, and I haven't read a lot of other accounts, although I have read in in Richard Gabriel's book called Acquittal. He talks about his role in the Anthony case as a jury consultant, and I had him on my show actually a couple of months back now, and we'll talk about that in a little bit. I think you mentioned him a little bit in your book by reference. But wasn't there some discrepancy about apparently some fellow that found the remains in August, and in case he could not, in case he was incarcerated?
A meter reader who was on his regular route doing his job for the county. That according to him, he needed to go to the bathroom, and instead of driving a few blocks away to a gas station or some other facility to be open, he just pulled his vehicle up, parked, and went into the woods. A few steps into the woods, and he said that he saw what he believed at that time to be a skull. And of course, you have in mind that the whole world is looking for this little girl at this time. There are posses, and there are helicopters, and there are all-terrain vehicles, and motorcycles, and horses, and people on foot, volunteers by the thousands, and alleged sightings everywhere and police getting tips, 6,000 or more tips of where Kaylee is, blah blah blah. Well, this meter reader, he said that he found a skull, and he rushed out of the woods because he also saw an eastern diamondback rattlesnake dead, and in the area, so he decided it's time to leave. Well, he called the sheriff's department, and they didn't respond. And he went home and he talked with his girlfriend about it. She suggested he call the sheriff's department again, and he did, and they didn't respond. And so he did it a third time. This time they sent a deputy to investigate what this civilian person, alleged to have found. And believe it or not, this deputy obviously didn't have a very good attitude about it, figured it was a hoax or whatever. He started to look in this area, slipped on the wet grass, fell on his butt, and he got mad because it had soiled his uniform. So he yelled at and screamed and abused and mistreated this poor meter reader and left. Well, that was the end of it. Nobody went in there, and nobody found, nothing was discovered. In December, several months later now, 4 months later after that was in August, then in December, he decided that he's going to go back and take another look. And there's some conflicting evidence about what his motives were or were not, but the bottom line is he went back allegedly to the same area, and this time he went in and he found the remains. And, of course, the interesting thing to know is that on each of these occasions when he had gone and had reported to the police or had been there himself, that was only just around the corner and down the block from where the Anthonys lived. And that whole street was saturated with television antenna trucks, investigators, police, constantly. They were stationed there. I mean, hundreds of news media people were within 300 yards. And nobody saw, nobody did, and the sheriff's department didn't do anything. So the bottom line is that when this fellow found, this the last time in December, he did call the sheriffs again, and it was very positive, and they responded, and he showed them, and sure enough, there was a remains. Ironically, as I revealed in detail, I hate to use that phrase I say all the time, in my book. Well, I don't know how else to say it, but I did reveal that the location, the site, the first main area of location of the remains of this child was 17 feet and 4 inches from the edge of the pavement of Hope Springs Drive, the road. Now, everybody stop and look for a second, the room you're in, and walk off 17 feet and 4 inches and tell me how the remains could have been there all that time with all these hundreds and hundreds of people, as I said, on foot, with horses, all-terrain vehicles, in every way searching, specifically trying to find the remains of this child. 17 feet and 4 inches. That's how far it was away.
And it wasn't like the body was... Now, I'm double-checking here. When you say that somebody went back in December, are you saying that's the sheriff's deputy that fell down and soiled his uniform and decided to go back and look? Or was this the meter reader that went back to look again?
Just the meter reader that went back.
So the meter reader goes back in December, and he because they didn't listen to him the first time?
He went back...
and reports it again.
I don't know what is in his mind, but it's obvious that he believed what he had seen and claimed to have seen back in August.
Right.
And for whatever reasons, he waited, and in December, and says, "By God, I'm going back," and he did, and discovered the remains, and he came. The important part of all that, and the important part of my strategy from the beginning of the case, was to discover and reveal how many people had searched that very area, the hundreds of people, We went through all kind of skirmishes to try to get that information that the state tried to prevent us from getting, because to prove that all of these people had searched that area and the remains were not there, but were discovered in December, proved conclusively that Casey Anthony could not have done that, because guess what? She was in jail.
Well, that was my next question. Was she in jail in August of what year are we talking about? 2008?
Yeah.
And yeah. Was she in jail in August of 2008?
Let's see. It depends on the exact. I can't remember where she was in jail initially at that time. Let me tell you this now, without going back to my calendar. She was in jail and then out of jail on bond and then back in jail.
But in any event,
so we know that at the time when he claimed to have first seen the remains, she was either in jail or under 24-hour surveillance from all the media and so forth in the house where she couldn't have gotten out. It depends on which day, but without question, from the time that after that until the remains were found in December, that whole period of time she was in jail. So there was an initial part of time from the missing, the determination of missing, that she was either in jail or in custody, or watched by surveillance from June on.
Well, how in the world
she was out? But in August, as I looking back on in August when he went there, she was in jail. So if the remains were not there, but then were later in December, that is as conclusive a proof as you can have that she couldn't have put the remains there. End of story.
Because you had hundreds of volunteers combing that area, and the jury would have to believe that the body had been moved to that area, and so either she did it or she had a co-conspirator do it. But either way, that's not proven by the prosecution's case.
Well, there's no such evidence of anything at all. I mean, just you can sit around making up, and you being a lawyer, you can sit around and postulate all kinds of things that could have happened and didn't happen, but there was no evidence of anything. All we know for certain is where the remains were found were 17 feet and 4 inches from the road. The state tried to prove there that they tried to explain and rationalize the failure to find by saying that it was underwater, but their own experts said it wasn't. And you just go from there. I mean, the bottom line is that there is just no physical possibility that Casey could have put that child's remains at that scene from the time that they were reported found, and until actually discovered. That whole period of time, she was in jail.
We're here with Cheney Mason. I'm George Yates with Justice for All, 1650 AM. We're going to take a short break here at the top of the hour for a little CBS News, and then we'll be back after a few messages, and we'll be back with Mr. Mason for the next hour. What I'd like to talk about in the next hour, Cheney, is you just mentioned earlier that, first of all, I know that you wanted to get the names of volunteers who'd combed this area. You wanted some of them, obviously, to come in and testify that, yes, I was with 17 feet 4 inches from the road. I was in that area in March or April or whenever this was, and there was no body there. And the government did their best to try to keep you from doing that. I'd like to come back and talk about how the government presented their case and obstructed justice, in your opinion, not only in that regard, but in many other ways in which they seem to have a win-at-all-cost mindset in the prosecution of Casey Anthony. We'll be right back after these messages with more with Cheney Mason.
WHKT is on Facebook and Twitter. Like us on Facebook, WHKT AM 1650. Follow us on Twitter at WHKT AM 1650 and stay in touch with K-Talk 1650.